Hello, good evening, everybody else. Thank you for joining us. Um, we're back with session two of our Talking the Bill of Rights series. For those of you who missed session one, it is recorded, and your library should be able to get that recording to you. If not, you can reach out either to the Shelter Island Library or the Westhampton Library, and we can help you out. I'm Mara Zonderman. I'm the head of reference at the Westhampton Free Library. My colleague, Terry Lucas, is the director of the Shelter Island Library. We are both former attorneys, sort of. I never practiced, but I have all the credentials. Um, and today we're going to talk about the First Amendment. If you were with us last time, you might remember we said we were going to talk about the whole First Amendment. But that was ambitious on our part. So we're going to cut it in half, sort of. Terry's going to talk about freedom of speech. I'm going to talk about freedom of the press. And we're going to finish up with the First Amendment in a couple weeks at our next session, because otherwise we'll be here all night. So I'm going to go ahead and start the presentation. And then please feel free to put questions in the chat. We will, hopefully get to them as we go. If not, we'll circle back when we're done with the presentation, um, and hopefully have a good conversation then. All right, Terry.
Hi, thank you all for joining us. If everybody survived all the snow. Um, I think we want to look first. We're going to take a look at the first slide
Oh,
here,
right,
just so we are very clear
right.
that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peaceably to assemble and to petition the government for a redress of grievances. So that is your First Amendment right there.
And whoops, and you can see it breaks itself up nicely into discrete sections. So we're not going to start at the top. We're going to start sort of in the middle
Yeah.
with speech.
Okay, so we will start with Congress shall make no law abridging the freedom of speech. And our Bill of Rights is everybody's business. I have to start off by saying that we could do an 8-week series on the freedom of speech series part alone. I realized, as Mara and I both realized, with our individual areas that we were going to address, there's so much to talk about with this First Amendment. So today, with the freedom of speech, we're going to talk about the following, because otherwise, again, even with just freedom of speech, we'd be here all night. So we're going to talk about the history of the freedom of speech clause, how speech became defined by the Supreme Court over the years, when is speech not protected, and how freedom of speech will be interpreted as technology changes in these days of AI and social media, etc. So next slide, we'll start with the history of the freedom of speech clause. So the free speech clause went through several iterations on its road to adoption. Madison combined the freedom of speech clause with the freedom of press in his first proposal. Then it went to committee. It was rewritten in committee to separate freedom of speech and press. And then there just wasn't a lot of debate about this, because, as Madison said, this Bill of Rights is enumerating simple acknowledged principles. And I think that all of the people involved with creating the Bill of Rights felt that these simple acknowledged principles didn't really need much debate. These were all things that everybody agreed on. And especially, as Mara talked about last time, if you look back at the Declaration of Independence and what caused all this in the first place, what made this all happen, were the things that were enumerated in this Bill of Rights. So, but then some challenges came along. So in 1798, we had the Sedition Act that was passed. The law would punish anyone who would write, print, utter, or publish any false, scandalous, and malicious writing or writings against the government of the United States, or either House of Congress of the United States, or the President of the United States, with intent to defame or bring them into contempt or disrepute. Jefferson and Madison condemned this act. They said this is completely unconstitutional. However, the Adams administration found it quite useful and used it to prosecute its political opponents. Um, the Sedition Act trials, along with the Senate's use of its contempt powers to suppress dissent, set off a whole firestorm of criticism against the Federalists who thought this was a good idea and contributed to their defeat in the election of 1800. So the controversies surrounding these trials and the Sedition Act were some of the first tests of the limits of freedom of speech and press both. The Supreme Court never explicitly ruled that this act was unconstitutional, but further down the road, the court recognized that there was a broad consensus that the act was, in fact, unconstitutional. In 1801, the act was repealed, and Thomas Jefferson pardoned everyone convicted under the act. So that was kind of our first challenge to freedom of speech. The next slide, please. Well, many think the First Amendment was as the jewel in the crown. This is the thing that starts everything off. In actuality, the First Amendment was the third when it started, so it wasn't put out there to be the be all and end all when the Bill of Rights was first proposed. So in the late 1700s and 1800s, we didn't see the Supreme Court really addressing the freedom of speech cases. This was because the First Amendment initially applied only to the laws enacted by Congress, and its provisions were really, really narrowly interpreted. So the court basically said, this is none of our business. We're going to leave this to the states. And, we don't need to really be addressing that. However, in 1925, the Supreme Court upheld the New York criminal anarchy statute, which resulted in this charming man, Benjamin Gillow, who looks just terrible. I mean, well, it's a mugshot, so of course he looks very dangerous. But he was convicted for writing and distributing something called the Left Wing Manifesto. So in this case, the court applied the free speech clause of the First Amendment to the states through the due process clause of the 14th Amendment. This may sound a little dry, but to me, it's very interesting that until the 14th Amendment came along, the First Amendment, the freedom of speech part of the First Amendment wasn't really considered all that important. But they incorporated the 14th Amendment. This was the process known as incorporation, and it allowed the Supreme Court, to start addressing freedom of speech in a number of cases. And this is what kind of got the ball rolling. So, but going back to 1919, before Gitlow, one of the very first cases about freedom of speech before the Supreme Court was Schenck versus United States. As a background, Congress had once again passed another kind of sedition act called the Espionage Act of 1917. And this act says, whoever, when the United States is at war, because we've got World War I going on, shall willfully make or convey false reports or false statements with the intent to interfere with the operation or success of the military or naval forces of the United States, to promote the success of its enemies, and whoever, when the United States is at war, shall willfully cause or attempt to cause insubordination, disloyalty, mutiny in the military or naval forces of the United States, basically came down to, you're going to be punished by a fine of not more than $10,000 or imprisonment for not more than 20 years or both. So this Schenck versus the United States was, I think, is the next slide. Schenck, went out, and he was a prominent socialist, and he was passing out leaflets, and he compared military conscription to enslavement. And interestingly enough, this was was a very famous opinion, yet they continued to uphold his conviction. Oliver Wendell Holmes set forth what he called the clear and present danger. I mean, we've all heard clear and present danger. So this was a test to judge whether speech is protected under the First Amendment. So he said, whether words are used in such circumstances and are of such nature as to create a clear and present danger that they will bring about the substantive evils that Congress has the right to prevent. So that was the test that was applied. And they found that Schenck's words did that. I don't, Mara, I look like you're coming on again. Um, this case is also well known because Holmes came up with the famous line that we all know about yelling fire in a theater. So he said in this case as well, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. So yeah, we have a First Amendment right to free speech, but we also there are some limitations there. And this was the kind of the first test that was going to be applied going forward. So, and then in 1969, that clear and present danger doctrine was updated in a case called Brandenburg v. Ohio, and it revolved around an Ohio criminal syndicalism law that prohibited public speech that advocated various illegal activities. And in this case, the person who had been convicted um, actually won his case. And this is Brandenburg. He was convicted because of his involvement in promoting, assisting in the filming of a Ku Klux Klan rally. And so the court in this case said, yeah, this law can't stand because the speech is not directed to inciting or producing imminent lawless action and is likely to produce such action. So now the test is, does it incite the action, and is it actually likely to promote that action? So that's the new test of the clear and present danger law. So that's some early history of the freedom of speech clause, but we're going to talk a little bit about how the definition of speech changed over the years, depending on who was in the Supreme Court, what was going on in the world in terms of wars or the Red Scare or the other things that happened in the United States over many years. So next slide. So over the years, the Supreme Court modified and expanded the definition of speech. Speech under the law has included the right not to speak, the right to wear symbolic clothing or symbols, the right to use offensive language to convey a political opinion, to engage in symbolic speech, and in some circumstances, to the donation of money or advertisement of commercial products. So speech got very big. So one of our early cases, this is Yetta Stromberg, who is a 19-year-old female member of the Young Communist League. And back in the late 1920s and early 1930s, California had something called the red flag law, and you could not display a red flag as an emblem of an opposition to United States government. So legal commentators say that this is the first case in which the court recognized that protected speech might be nonverbal or a form of symbolic expression. So this opinion was written by Chief Justice Charles Evan Hughes. He had a really strong First Amendment vision. So this is one of those cases where the court had a vision, and this was a case that he was allowed to state this vision in his opinion. And he held that speech must be protected that would allow Americans to govern themselves. That to him was very important. Americans had to govern themselves. And if they couldn't say what their opinion was, how could they ever govern themselves? So California repealed the law, and Yetta went free. Next slide. So then in Thornhill versus Alabama, the Union president, Byron Thornhill, was arrested in a picket line. So we've got a picket line in that left-hand picture if you're looking at the screen. In 1940, the Supreme Court struck down the Alabama law that was used to arrest Thornhill. The law made it unlawful for any person without a just cause or legal excuse to loiter or go near any place of lawful business for purposes of or with the intention of influencing other persons not to buy from, deal with, or be employed at such place of business. So basically they said you can't picket. You can't picket. You can't tell people, that they shouldn't shop at Target, which is something that has happened recently. That is considered legal free speech. Um, so the court found the freedom of speech and of the press guaranteed by the Constitution embraces at the least the liberty to discuss publicly and truthfully all matters of public concern without previous restraint or fear of subsequent punishment. And they went on to say the dissemination of information concerning the facts of a labor dispute must be regarded as within the area of free discussion, which is guaranteed by the Constitution. So again, that freedom of speech clause grows a little bit, a little bit, a little bit. So we're going to move forward to 1969 when Mary Beth Tinker and 5 other students. Mary Beth was in middle school when she did this. Mary Beth is on the right there with the black armband. She was suspended with her with her other students for wearing a black armband to support a Christmas truce and to protest the death of the Vietnamese and American soldiers. Tinker was an 8th grader at the time. She was represented by the ACLU, and the students sued for freedom of speech after their suspension. And this is again one of those times that the court took on this case and found that the students had a right to express political and social views by wearing the black armbands to protest the Vietnam War, and that was considered protected speech. It also was the first time we heard the words that free speech does not stop at the schoolhouse doors. And that's something that Mara and I have talked about before when we get to when we've talked about censorship and other programs that we've done, that under the Island Trees case, where the kids, even if you're a student, you have a right to free speech. And then is one of the ones that's difficult for a lot of people, which is our center picture. And this is Johnson v. Texas. This took place in 1984 at the Republican National Convention. Johnson was in a protest march. When the protest march reached City Hall, he pulled out some kerosene and he lit the flag on fire. He was arrested. The case made its way through the court. And in 1989, Texas, so this was 84 that this happened. 5 years later, he got to the Supreme Court. And they held that the burning of the American flag was a protected form of symbolic political speech. A bedrock principle underlying the First Amendment is that the government may not prohibit the expression of an idea simply because society finds the idea offensive or disagreeable. And that's a hard one for some people, but it's a freedom that is widely expanded so that we can all say what we want to say to a certain extent. This last August, and I think this kind of proves the strength of this First Amendment, President Trump passed an executive order about the prosecution of those that burn the flag. But the order had to say, notwithstanding the Supreme Court's ruling on the First Amendment protections, the court has never held that the American flag desecration conducted in a manner that is likely to incite imminent lawless action or as an action amounting to fighting words is constitutionally protected. So basically, they're restating the law is that you can't incite imminent violence and you can't, go against the fighting words theory. So it continues. My administration will act to restore respect and sanctity to the American flag and prosecute those who incite violence or violate our laws while desecrating the symbol of our country to the fullest extent permissible under available authority. So even this executive order can't really go beyond what is allowed by this freedom of speech principles set forth by the Supreme Court. So I thought that was kind of interesting that the backpedaling on that was we don't want you to burn the flag. We think it's really awful, but yet you're still subject to what the Supreme Court has found to be permissible. And then finally comes the topic of hate speech. And this I find really interesting because in Europe, hate speech is not considered to be free speech. In the United States, the belief in freedom of speech is so strong that hate speech is not found to be unconstitutional. So finally so the United Nations Strategy and Plan of Action on Hate Speech defines hate speech as any kind of communication in speech, writing, or behavior that attacks or uses pejorative or discriminatory language with reference to a person or a group on the basis of who they are. In other words, based on their religion, ethnicity, nationality, race, color, descent, gender, or other identity factor. So that is pretty clear statement. And European and EU law curtails the right to the freedom of that expression. Um, European Convention of Human Rights says freedom of expression carries with it duties and responsibilities. So it's a completely different view that what you say, you have limitations. You have duties and you have responsibilities. Our Supreme Court and the United States kind of takes a different view of this. And I think it is because this is so intrinsic to who we are. Um, so in 1992, in RAV versus St. Paul, the court found an ordinance banning hate speech that might arouse anger, alarm, or resentment on the basis of race, color, religion, or gender. They found that law was unconstitutionally discriminating based on the content of expression. And because it addressed certain biases and not others, it was an unconstitutional law. So I think that's interesting, and I think we'll see. I think we'll see. I don't know if things will change with that. It's hard to tell with that one, particular one. So that kind of tells you how the word SPEECH has changed underneath the Supreme Court over all these years, and it will probably continue to change. So, what speech is not protected? Because there is certain speech that is not protected. So, speech that is directed to inciting or producing imminent lawless action and is likely to produce such action. We're back again once at the fighting words and clear and present danger idea. Obscene material and child pornography. So, again, don't go into a crowded theater and start yelling fire. That's is prohibited. Obscenity is not protected by the freedom of speech doctrine, but defining obscenity has not always been easy. And one of the things you always hear about it and you learn in law school, and I think many of us has heard Justice Potter Stewart, who famously said he would not attempt to define pornography, but he knew it when he saw it. That's not very helpful for the law. So first, one of the obscenity cases took place in the early 1970s. Marvin Miller set out a mass mailing advertising the sale of adult material and was convicted of distributing obscene material. Case eventually found its way to the Supreme Court, and in Miller, California, the Supreme Court mapped out a three-part definition of obscenity. One is the average person applying contemporary community standards must find the word taken as a whole appeals to this is a word I never can say, prurient interests that it depicts or describes in a patently offensive way sexual conduct as defined by state law. And this was a big one, the work taken as a whole lacks serious literary, artistic, political, or scientific value. So in Miller's case, they felt that the material was not protected by the First Amendment and was therefore was obscene. So in 1982, we had child pornography added to the categories of speech not enjoying the protection of the First Amendment in New York v. Ferber. And Mr. Ferber owned an adult bookstore and sold a video showing some sexual activity between underage participants to undercover agents. And the court found that not only could the state ban child pornography on obscenity grounds, but in the interest of protecting children, child pornography could be banned without first determining whether it was obscene or not. I know I feel like those things kind of go together, but again, it kind of made any involvement of children is even stronger in terms of not being allowed speech. And but again, in 2002, the Supreme Court struck down the Child Pornography Prevention Act of 1996 as being too broad. And I found this a really interesting statement by Anthony Kennedy. Justice Anthony Kennedy wrote, "First Amendment freedoms are most in danger when the government seeks to control thought or justify its laws for that impermissible end. The right to think is the beginning of freedom, and speech must be protected from the government because speech is the beginning of thought. And I kind of hoped that thought came before speech, but okay. I think I can see that we want to protect the children, but we also don't want to make wide sweeping laws that could affect people in other ways. So that's where we are with what you can't do. Now, what are we going to do with AI? So I put 3 links here. This is recorded. If you want me to send you the links so you can click on them, you just get to shoot me an email at Shelter Island Library, and it's very interesting. As with so many things, AI, it is very interesting to find out how freedom of speech is going to be affected by it. So, according to the Foundation for Individual Rights in Education, the First Amendment doctrine does not reset itself. And they're saying it's not that big of a problem. It doesn't reset itself after each technological advance. And modern First Amendment jurisprudence has navigated the advent of television and motion pictures, personal computers, the internet, smartphones, and more. And the court has even found computer code to be speech. So, the creator should have First Amendment protection. And if the technology is used for any of the non-protected categories, the person creating the speech would be liable. So, again, they could not blame the actual chat GPT for libel. They would have to blame the creators of the chat GPT. But on the other hand, Tristan Harris, who's the co-founder of the Center for Humane Technology, had a fascinating conversation with 2 law professors, and that one is the second link there. He said, so often these judges are relying on statutes and precedents that were written 100 years ago or more by people who couldn't even conceive of the technology that we have today. AI right now might be a large language model that's producing outputs, but a few years from now, we might be talking about AI more like an invasive species that is self-replicating and intelligent and wants to acquire resources. And I'm sure when they wrote the Bill of Rights in 1791, they could not have fathomed a computer, much less an AI system. So how do we reconcile the words that are written down centuries ago and the spirit of those words, and even trying to interpret the spirit of those words as we're talking about brand new conceptions to reckon with today? So I'm not going to give you an opinion on this because I feel like this is the Wild West. We don't know what's going to happen. I think it's going to be very interesting. I know the law will change and morph as it always does to somehow accommodate new technologies and new ideas. And it's going to be a very interesting time. So keep your eye out. If you have a chance to look at any of these links, it's kind of takes both sides, and it is interesting to kind of think about what the repercussions might be. So I just gave you a lot of information. I gave you a lot of cases, but freedom of speech at the end of the day, freedom of speech is a core, beloved freedom of Americans. But as you can see, it didn't remain static from 1791, and it changes all the time. And we just open our eyes and hold our breaths, and we're going to see what the future holds. So, with that, we'll take a deep breath because that's been a lot. And we're going to turn it over to Mara, who's going to talk a little bit about the freedom of press.
Yes, thank you. And again, if you have questions as we are going along, do feel free to put them in the chat and we'll hopefully get to all of them when we're done. All right, so Congress shall make no law abridging the freedom of the press. Going to give you a little bit of the history, and then there's sort of 5 major aspects of freedom of the press: prior restraint, mandatory publication, libel, the right to gather news, and the right of access to information. So first, a little bit of history. So when we talk about the First Amendment, in the Declaration of Independence, it talks about inalienable rights, rights that are just part of, have been attached to humanity as long as civilized society has been a thing. Freedom of the press is a little bit different because nobody thought anything about it until there was a press, right? Until the advent of the printing press, there was no mass dispersion of information at all. Um, so the printing press um, comes around, and not much longer after that, in 1644, um, John Milton published, speaking of things we can never pronounce, the Areopagitica. I'm sure I butchered that, but anyway, he wrote it in response to the British Parliament's passage of a law requiring the government to approve all books prior to publication. And the gist of what he said is that that was inappropriate. Um, Sweden, interestingly, was the first country to make the freedom of the press official. In 1766, so a couple decades before our Bill of Rights, um, the Swedish Parliament passed the Freedom of the Press Act, which abolished the Swedish government's role as a censor of printed matter, and it allowed for the official activities of the government to be made public. More broadly, the law codified the principle, which has since become a cornerstone of democracies throughout the world, that individual citizens of a state should be able to express and disseminate information without fear of reprisal. The preamble to the act says that the great advantages that flow to the public from a lawful freedom of writing and of the press, and whereas an unrestricted mutual enlightenment in various useful subjects not only promotes the development and dissemination of sciences and useful crafts, but also offers greater opportunities to each of our loyal subjects to gain improved knowledge and appreciation of a wisely ordered system of government. While this freedom should also be regarded as one of the best means of improving morality and promoting obedience to the laws when abuses and illegalities are revealed to the public through the press. So we took that idea, and there's a lot sort of packed into that, that basically being able to freely disseminate your ideas and discuss them, and that includes ideas that might be um, critical of the government, was a necessary part of preserving overall liberty. Um, when we started to think about that in this country, um, we took it pretty seriously. The Massachusetts Bill of Rights says the liberty of the press is essential to the security of freedom in a state. So they're tying it very closely to this idea that far from subverting the security of the state, free criticism, freedom of the press is essential to that security. Terry told us a little bit about the Alien and Sedition Act. Madison, not a fan, um, said, "We shall find that the censorial power is in the people over the government, and not in the government over the people." And the last sort of uh, point on this is from a case called Mills v. Alabama. This is Justice Black wrote the opinion. He wrote, so this was 1966. So by 1966, he said there is practically universal agreement that a major purpose of the First Amendment was to protect the free discussion of governmental ideas. The Constitution specifically selected the press to play an important role in the discussion of public affairs. He went on to say its suppression of the right of the press to praise or criticize governmental agents and to clamor and contend for or against change muzzles one of the very agencies the framers of our Constitution thoughtfully and deliberately selected to improve our society and keep it free. Which leads us to this question of preferred status, which is essentially the question of whether the press, as an institution, has any additional freedom that's not already guaranteed by the free speech clause. Or, put another way, does the press as an institution have free speech rights that individuals don't? Um, and in the 70s, Justice Stewart, who we heard about before, and Terry, I'm so glad you mentioned him because I'm pretty sure no presentation on the freedom of speech can be made without mentioning that he knows it when he sees it. I think that's actually a law. Um, but he said other things. So in 1975, in a law review article, He points out that most of the provisions of the Bill of Rights protect the rights and liberties of individuals, but the Free Press Clause protects the right of an institution, the publishing business, making it, quote, the only organized private business that is given explicit constitutional protection. So he's arguing that there is a preferred status. He goes on to make a sort of Talmudic argument. He says it is tempting to suggest that freedom of the press means only that newspaper publishers are guaranteed freedom of expression. They are guaranteed that freedom, to be sure, but so are we all because of the free speech clause. If the free press guarantee meant no more than freedom of expression, it would be a constitutional redundancy. Between 1776 and the drafting of our Constitution, many of the state constitutions contained clauses protecting freedom of the press while at the same time recognizing no general freedom of speech. By including both guarantees in the First Amendment, the founders quite clearly recognized the distinction between the two. He then goes on to draw out this argument that I think really encapsulates why we have such reliance on freedom of the press. He compares a free press to the checks and balances of the federal government. The three branches check and balance each other, as we all know from civics. And he argues that the founders included the Free Press Clause to create a fourth institution outside the government as an additional check on the three official branches. The metaphor of the Fourth Estate, as it became known, came from Thomas Carlyle's writing about the British government's attempt to censor the press about a century before that. So Potter went on to say, the press could be relegated to the status of a public utility. The guarantee of free speech would presumably put some limitation on the regulation to which the press could be subjected. But if there were no guarantee of a free press, government could convert the communications media into a neutral marketplace of ideas. Newspapers and television networks could then be required to promote contemporary government policy or current notions of social justice, which is an interesting thing. And in 1975, perhaps that is what they thought would happen. I will say, to me, it sounds sort of hopelessly naive to assume that without the Free Press Clause, the worst thing that would happen would be a neutral marketplace of ideas. But we'll set that aside. In counter to his argument, Chief Justice Berger, a few years later, said the clause standing alone may be viewed as a protection of the liberty to express ideas and beliefs, while the press clause focuses specifically on the liberty to disseminate expression broadly. Yet there is no fundamental distinction between expression and dissemination. The liberty encompassed by the press clause, although complementary to and a natural extension of speech clause liberty, merited special mention only because it had more often been the subject of official restraints. So, to Chief Justice Berger, the press doesn't get any special treatment. It had just been more systematically subjugated, so to speak. He says, because the First Amendment was meant to guarantee freedom to express and communicate ideas, I can see no difference between the right of those who seek to disseminate ideas by way of a newspaper and those who give lectures or speeches and seek to enlarge the audience by publication and wide dissemination. So that was he actually was writing on the bench for that. But it was a concurring opinion in a case that really had more to do with whether corporations had the same rights as individuals. So that opinion has never really become the way that the court has thought about freedom of the press. But what do they think about it now? So one big question is this question of prior restraint, which is basically, can the government prevent a newspaper, of other types of publications as well, but most of these cases have to do with newspapers. Can the government prevent a newspaper from publishing information that they already have? The first time it came up was actually in 1931, a case called Near v. Minnesota, where Minnesota's public nuisance law provided that anyone who regularly published or circulated a malicious, scandalous, and something malicious, scandalous, and defamatory could be enjoined from continuing to do so. When the Saturday Press of Minneapolis published articles accusing local officials of being implicated with the mob, those officials brought the paper to court, and were granted an injunction that prevented publishers from continuing to publish at all. They basically shut the paper down. The case gets up to the Supreme Court, and Chief Justice Hughes called upon an idea dating back to Blackstone, who is the cornerstone of many of our legal theories, from the mid 1700s, that the government can't put any prior restraints on the press, and that the government is not allowed to prohibit the press's ability to publish information it already has. And that would become uh, very important 40 years later. Many of you may recognize this. This is part of the Pentagon Papers release in the New York Times. Um, the government once again sought to stop both the New York Times and the Washington Post from preventing the publication of Secretary of Defense McNamara's classified study of the history of U.S. decision-making process on Vietnam policy on the basis that such public disclosure of classified information posed a threat to national security. And I did not realize this. But the court actually issued a per curiam opinion in this case, which basically means there was no one specific author. They spoke with one voice, um, but they didn't say much. They basically said, nope, can't do that. Government cannot prevent the publication of this. They said the government did not meet the heavy burden of showing justification for the imposition of such a prior restraint, but they really didn't go into detail, which limits how much we can use this as precedent, except that it has become part of our national identity. That um, freedom of press means that if journalists get this information, they can publish it. Um, and we've seen that in many more recent things. There were a couple of concurring opinions that were interesting. Justice Black had some very strong words for the lower courts, which had allowed an injunction to be against the papers for about a week. This was totally fast-tracked. I don't think any case has ever really moved so fast that it went from suit all the way to the Supreme Court within like 2 weeks. But he said Justice Black lambasted the lower courts for enjoining the Pentagon Papers from being published, saying every moment's continuance of the injunctions against these newspapers amounts to a flagrant, indefensible, and continuing violation of the First Amendment. And then in other concurring opinions, several of the justices reinforced this idea that the press is meant to be the fourth estate, that the freedom of the press, we have it specifically to allow for criticism of the government. Another question, can the government require a publication, a newspaper, to publish certain things? Um, Surprisingly, not. The answer is no. And that's a case from 1974 um, against the Miami Herald, which published two editorials criticizing a candidate running for House of Representatives. And in Florida at the time, there was a right of reply statute, which gave candidates criticized by any newspaper the right to have their response to the criticisms published. But the Herald refused to publish the particular candidate's response and challenged the statute as a violation of the Free Press Clause. Chief Justice Berger, we have here, identified the key issues of the case. Appellee's argument that the Florida statute does not amount to, so the candidate's argument that the Florida statute does not amount to a restriction of their right to speak because the statute in question here has not prevented the Miami Herald from saying anything it wished, is not the question, he says. Compelling editors or publishers to publish that which reason tells them should not be published is what is at issue in this case. The Florida statute operates as a command in the same sense as a statute or regulation forbidding an appellant to publish specified matter. So it doesn't matter. You can't say yes, you can't say no. Freedom means freedom. And he goes on to say the Florida statute fails to clear the barriers of the First Amendment because of its intrusion into the function of editors. A newspaper is more than a passive receptacle or conduit for news, comment, and advertising. The choice of materials to go into a newspaper constitutes the exercise of editorial control and judgment. It has yet to be demonstrated how governmental regulation of this crucial process can be exercised consistent with First Amendment guarantees of a free press as they have evolved to this time. So, in other words, government has no role. Government can publish its own newspaper, basically, but doesn't have anything to say about what other newspapers say. So no prior restraint, no mandatory publication. What about libel? Can a newspaper print something that's not true about, in particular, a public official? So this is an advertisement that was placed in the New York Times in 1960, I believe. Martin Luther King had been arrested and faced trial in Alabama for tax fraud, which whatever. To help cover his legal fees, a group of allies purchased this full-page ad asking for donations. The ad, it's much too small to see, but it describes several actions taken against student protesters and attacks on King. However, the ad contained several unintentional minor errors, including false descriptions of police actions in Alabama against a student sit-in. Montgomery's commissioner, the city of Montgomery's commissioner for public affairs, L.B. Sullivan, sued the paper for libel under Alabama's libel law, which allowed a public official to be awarded civil damages for any material printed about them that was false and would tend to injure a person in his reputation or to bring him into public contempt, even without showing that there was any actual injury or intent to cause injury to their reputation or otherwise. So the mere fact of printing a falsehood, according to the libel law, entitled the person about whom it was published to damages. The lower court awarded Sullivan $500,000 in damages, which would be a little over $5 million today, and would likely have put the Times out of business. And in the unanimous opinion, which is something you don't see very often anymore, written by Justice Brennan, the court ruled for the Times. Obviously, they didn't go out of business. When a statement concerns a public figure, the court held, it is not enough to show that it is false for the press to be liable for libel. Instead, they must prove that the statement was made with actual malice. And in the context of libel, actual malice doesn't mean meanness. It means a knowledge of falsity or gross recklessness as to the truth. So somebody can only recover damages if they can prove that the newspaper knew they were printing a falsehood that was damaging, or published it and didn't do their due diligence, basically, where they were reckless as to the truth. So no prior restraint, no mandatory publication. I already forgot the other thing. No, but libel is, there's a high bar. Let's put it that way. There's a high bar for people to have to prove libel for in publications. So the last thing is this question of reporter's privilege, or also thought of as the right to gather news. In 1972, and I will say a lot of our freedom of press jurisprudence comes from the 70s, because, that was Vietnam, Watergate, the Pentagon Papers, all of that happened at the same time. And so there was a lot of stuff going on, and there has not been a lot of case law since. So what the court said in the late 60s, 70s, early 80s is still the law of the land, pretty much. But so here's the question. The argument was that in order to gather news, a reporter might have to promise anonymity to a source. And if the reporter is required to divulge the source's identity, the source so identified and other confidential sources of reporters will be measurably deterred from furnishing publishable information, all to the detriment of the free flow of information protected by the First Amendment. And in this case, these three reporters each had confidential sources, and they had been summoned to appear before a grand jury to testify. One of them, uh, the case was about um, drugs, and in the other two, they had insider information from the Black Panthers. And they went and said, we are not going to disclose our sources. Um, Justice White said the issue is whether requiring newsmen to appear and testify before state or federal grand juries abridges the freedom of speech and press. We hold that it does not. Now, I will tell you, I watch Law and Order. I was kind of surprised to read that. And I sort of started looking, I was like, wait, did they overturn that? What's going on here? Um, at the federal level, at the Supreme Court level, there is no reporter's privilege. Um, he says the heart of the claim is that the burden on news gathering resulting from compelling reporters to disclose confidential information outweighs any public information, any public interest in obtaining the information. So there is no First Amendment violation because there are no intrusions upon speech or assembly, no prior restraint or restriction on what the press may publish, no express or implied command that the press publish what it prefers to withhold, no penalty, civil or criminal, related to the content of published material. The use of confidential sources by the press is not forbidden or restricted. Reporters remain free to seek news from any source by means within the law. The court seemed intent on considering journalists to be the same as ordinary citizens when it comes to answering questions before a grand jury, and found no reason to create an exemption, having previously found that the First Amendment does not invalidate every incidental burdening of the press that may result from the enforcement of civil or criminal statutes of general applicability. Under prior cases, otherwise valid laws serving substantial public interests may be enforced against the press as against others, despite the possible burden that may be imposed. The court has emphasized that the publisher of a newspaper has no special immunity from the application of general laws. He has no special privilege to invade the rights and liberties of others. So don't go to the Supreme Court and try to keep your source confidential, interestingly. But as it turns out, they didn't get it totally wrong on Law and Order. Um, the court has not addressed this issue in the 55 years since this case, but has allowed lower court rulings that do protect a reporter's privilege to stand. And currently, 10 of the 12 circuit courts have recognized some form of reporter's privilege. In addition, 49 states and the District of Columbia have either had prior to this or have enacted since some kind of shield law protecting journalist sources legislatively or have recognized reporters' privilege judicially. So either there's a law on the books in the state or the courts have said that there is a reporter's privilege similar to um, clergy privilege or doctor's privilege. Side note, Wyoming is the only state that has neither. And according to the Reporters Committee for Freedom of the Press, Wyoming doesn't have any such law because journalists are very rarely subpoenaed in Wyoming. So the issue hasn't come up. So,
There
okay,
you
good.
go.
Good for them. The laws, the laws and the court rulings vary in exactly who the privilege protects and under what circumstances. But across most of the countries, journalists do have the right to protect the confidentiality of their sources, even in the face of a subpoena. Um, New York, and I know some of you are here from New Jersey as well. New York and New Jersey both have pretty strong shield laws, providing an absolute privilege from forced disclosure of materials obtained or received in confidence by a professional journalist or newscaster, including the identity of a source. And it applies in both criminal and civil contexts and to information passively received by a reporter. So you don't have to have, your Mr. X whose identity you're going to keep secret. However you got the information, a reporter does have the right to not share that. Um, so that is where we stand with freedom of press. Um, it's a
Wow.
lot. Yeah.
Can you imagine
Um,
us trying to do the entire First Amendment tonight? Because we've got you through at an hour already. So
right.
we do,
Um,
Mara, we do have a couple of questions.
yeah.
So I want to start with some. We did some in the chat and some in the questions. Thank you all for asking the questions. But we've got someone saying, "Why is there truth in advertising but not truth in politics? when politicians are in the business of politics, which affects most everything. And I think that and again, is, anybody else feel free to join in on this. So I think it's more a matter of fraud with the truth in advertising than it is freedom of speech. But what do you think, Mara?
I think truth in advertising, the advertisers are not considered um, the press. So as far as my half of this
Hmm.
goes, um, they don't have the same rights. And I think, as we go through more of this, we're gonna hear more and more about, the government can only restrict freedoms in the face of a compelling argument.
Hmm.
The standards vary, we'll get into it a little bit, but I suspect that truth in advertising any laws regarding truth in advertising have to do with um, the government having a compelling reason to make sure that people selling products aren't making it up.
Yeah.
If I
Yeah,
if
it's
I
kind of
had,
more consumer protection than freedom of speech.
yeah,
And
exactly.
don't probably get either of us started on political speech. So that's that's a whole other can of worms that would take us again a long time. But somebody said, please contrast our country to the recent arrest of a British man for posting his disagreeable opinion, please. I'm not exactly sure exactly what we're talking about there, so I can't really comment on that other
Yeah,
than to say, again, there are different standards in Europe than there are in the United States. I think that would be my simple answer to that without further information.
yeah. I rely on my Anglophile husband to keep me apprised of what's going on in Britain. So Sam, if you want to text me and fill me in on that, we'll maybe get a little bit of an answer. But yeah, I can only say they
They
have
have
different laws there,
different,
and I
yeah.
don't know what they are.
We do have a question about how does the freedom of speech apply to the right to record the actions of police or ICE? And again, I just took a whole seminar on how to deal with the ICE in the public library, and one of the things that came up over and over again is it's federally prohibited to interfere. So I think that's, and again, we actually have two questions on ICE, and somebody else said inciting or producing imminent lawless action is likely to produce such actions. Looking at this in the context of ICE, some might say the demonstrations would fall into clear and present danger. Others would say it's protected under freedom of speech. That is a great debate for people, and it depends on what view of the actions, and it comes down to facts. Are people that are protesting exercising their right to free speech, as long as they're not being violent? That is again another. It's a good debate. That's the thing. I obviously everyone has their opinions on this, but again, we have the right to protest in this country. We have the right to speak, but we don't have the right to incite violence. And what does inciting violence mean in this particular case? So yes, I think, personally, I think that you should be able to record the actions of police or ICE, because it's a right to show what's going on in a way. If you push somebody so you can get in there to record it, or if you're aggressive with it, then it's a different story. So I mean, it's a very lawyerly kind of thing to say, because it's like, you know you're always taught to take both sides. But I, I think I think it's a big question, and I'm not sure it's one that I can answer. So here's a one for Mara. Um, sorry.
Well, I just had one response to that as well.
Yeah.
Um, the first question about how does freedom of speech apply to the right to record the actions of police or ICE? Part of that is something I didn't get into at all with freedom of
Mhm.
the press, which is who is a journalist
I
and
was gonna
what
say, who's the press,
what
right?
is the press, right?
Yeah,
And the answer to that question has changed a lot over the past 20
true.
years or whatever. And there's no clear answer. So part of the question would be, is it just the guy on the street recording, or is it a member of some recognized part of the press because I think you would get two different answers. Not that I agree that there should be a different answer, but I think there are different answers. Um, and I think, it takes a while for the courts to catch up with technology.
That's true.
Terry mentioned AI. We don't really know. And I think the same is true. Everybody has a camera in their pocket now, and the courts haven't really had much of an opportunity to figure out what that means in terms of our various freedoms.
And we have podcasters and bloggers and citizen
Right.
reporters, and are they the press? Or are they not the press? There's a lot of open questions
Yeah.
about that. And we have one final question, which again I think is how are the actions by the Pentagon to restrict reporting to official press releases consistent with the freedom of the press? And
I, here's the thing, and we're going to talk about this more next time also. If you had asked me that question 2, 3 years ago, I would have said, "What are you even talking about? They can't do that." And I still say that.
mm,
Um, I think that if we start to see court cases, um, 2 years ago, I would have said, if we start to see court cases, um, there's no way it will stand. The courts will say, no,
we don't know.
we don't
I
know.
mean, as we've seen, like looking at all of these things over time, a lot depend. When you go to law school, well, first of all, I'd say look to your left, look to your right. Two of you will be gone. That's to terrify you. The other thing they say is a lot of times decisions are based on what the judges have for breakfast.
Also,
So we're
also,
always,
it depends. That
yeah,
was another big one. It
we
depends.
it depends. We're always dealing with human beings making these decisions. These decisions are not coming down from God. They're human beings who have opinions, who have backgrounds, who are bringing their life experiences to it, and it depends on the makeup of the Supreme Court in terms of constitutionality of a lot of these things. So, you have all been extremely patient.
Oops.
As we have
I
gone.
do want to say I got some information on this question of what's going on in Britain.
Oh, tell me.
Um, yes, Sam says he's not heard of this specific incident, but he says there are very strict controls on select classes of speech in Britain. But the system is entirely different. But that's a very interesting point because it goes back to what we were saying last time about how so much of our legal framework, the Constitution, the Bill of Rights, is in response to what was happening in Britain. It was basically them saying, "We don't like the way you're doing it. We're going to do it
Do it
differently."
different. Yeah.
Concepts of like freedom of the press, freedom of speech are understood entirely differently in Britain. So um,
So
that's a
this is
whole separate
and
presentation.
to anybody over a certain age watching this, you can see what has, I mean, when you say something about the 70s being 50 years ago, I laugh, haha, but it's true. And I mean, even over the last 50 years, so many things have changed and so many things have morphed, and they will continue to do that. And we just hope that those basic tenets of freedom of speech and freedom of press can hang in there through all the challenges. So I'm trying to see if there's anything else that we need to say. But next time we're going to continue the First Amendment, and then we're going to attempt to blend the Second, Third, and Fourth Amendments. But as this goes on, we may be just morphing it a little bit to make it work so that we can really cover at least part of what we want to cover. There's so much to talk about as always, but I hope you've all enjoyed this. This is going to be recorded, so you'll be able to get the recording from your library. And would really enjoy talking to you all about this and look forward to First Amendment Part 2. Thanks, everyone.
Thank you, everybody.